inundated with legal analysis, interpretations, and all sorts because of the ruling by the Speaker and the subsequent resort to the Supreme Court. I mean, before the ruling of the Speaker, there had been a writ at the Supreme Court, and then subsequently the Speaker went ahead to deliver the ruling, then an ex parte motion at the Supreme Court again, and now here we are. Both sides are claiming to be in the majority, and the NDC, for instance, have said that for them, it would have to take the Supreme Court to come into the chamber to come and enforce that particular ruling. First of all, there are many who have talked about the procedures that were adopted before we got to this place, especially with that of the Supreme Court. You have argued that procedurally the Supreme Court was wrong.
Well, I maintain that position. But first of all, let me say a good morning to your listeners. And if they are viewing it too, let me greet them. Now, I maintain that the manner these things happened in the Supreme Court was absolutely wrong. And I think even more, the conclusion the Supreme Court came to on that application for stay of execution, it was before it, was absolutely wrong. And so I maintain that position. And some of the pronouncements which were made in that ruling really are quite strange to what we know as legal principles. And so I maintain the position of the Supreme Court. Procedurally, what they did was wrong. And substantively, in terms of the grounds for granting a stay of execution and the conditions for the grant really were not considered. And I think that's quite worrying.
And
I mean, the Supreme Court.
Can you kindly take us through the procedure that should have been that wasn't?
Now, I think these issues have been dealt with over and over again. Now, first of all, you recall from facts that are available to you that on the 15th of October, Honorable Apenyo Makin had actually taken a writ at the Supreme Court, invoking the Supreme Court's jurisdiction. And as part of that writ, the application for injunction, which I believe was seeking to restrain the Speaker from going ahead to take a decision or to make a statement on the fate of the 4 MPs who may have been caught under Article 97, Article 97 plus 1, G and H. So the intention was to restrain the Speaker. At the time, the Speaker had not decided. So the writ and the application was before the Speaker decided. The Speaker decided subsequently, I think on the 17th of October. So clearly, the circumstances had changed, all right? Which meant that the application for injunction, which had been filed previously on the 15th, to accompany the writ that had been issued in the Supreme Court, had become its use. It had become irrelevant, all right?
Because the Speaker had gone ahead to declare the seats vacant.
To declare the seats vacant. I'm particularly careful not to continue to say that the Speaker had declared the seats vacant.
Okay.
The truth of the matter is that, it does appear from the reading of Article 97 that it's an automatic process.
Okay.
I don't even think the Speaker ought to have done this matter. For instance, look, Article 97 tells you that when the conditions which have been stated down there in the various paragraphs exist, right, the member shall vacate his seat.
Okay.
It is the responsibility is on the member. You can take a look at it again. The member has a duty to vacate his seat if those conditions down there have arisen.
There are those who also argue that in relation to that, those who say it is not automatic say that it is within the purview of the High Court to declare a seat vacant. Therefore, when these issues arise, people can take it up to the High Court and say that on the facts of the case, this is what has happened. Therefore, declare these seats vacant.
Precisely. So under Article 97, what the Speaker did was not a declaration of the seat as being vacant.
Okay.
All right. Now, if you look at Article 99, I don't have the position with me, where, for instance, the High Court has been given some powers when it comes to issues of vacancies and all that. If you look at the language, okay, and as you said, I mean, anybody else could have taken the matter to the High Court. So if, for instance, the MPs involved had walked out of Parliament on their own, all right, then someone could take on the issue and say under Article 99 that the manner in which you left your seat or your seat became vacant, there's a question. So if you look at 99, it tells you that the issue of whether or not there's a question as to how you actually vacated your seat is a matter that can be determined by Parliament. Can be determined by the High Court. Sorry,
okay.
By the High Court.
Okay.
And so the High Court. So I mean, in that scenario, the High Court will not be engaging in an issue of interpretation. They would only, for instance, be applying the law.
Applying the law. Okay.
So I mean, where we are now, and I think that this matter should not have even gone to the Supreme Court in the first place. Because if the MPs had walked out of Parliament without the Speaker making a statement on that, then an issue will arise whether the way they walked out of Parliament, believing that the conditions had been met, would have been an issue for the High Court to determine. And then the High Court will come to determine whether how you left your seat or so, for instance, was actually in accordance with the law. All right. So I first of all think that the matter should not have even been taken to the Supreme Court. And I think the practice of rushing to the Supreme Court and invoking its jurisdiction and giving it the leeway to come into the affairs of Parliament is quite worrying.
And others have expressed similar situations. And the Speaker did mention that it is the same parliamentarians that are essentially destroying their own privileges or the boundaries that they enjoy by taking some of these matters up and how they approach it and all. You said you don't want to describe what the Speaker did as a declaration of the seats being vacant. So what did he do?
I don't want to do that.
So what did he do?
I don't want to do that. Well, I think that if you look at the equation and from the way I look at Article 97 and 99 together, right? I mean, ordinarily, what I think the Speaker did was a matter of mere procedure.
Mere procedure.
But really, it was a matter of mere procedure. I mean, the Speaker was not doing an interpretation of the Constitution. He was just applying.
He was equally applying.
He was equally applying the law. And if the Speaker did an interpretation of the provision, then we'll say that the Speaker was intruding into the ambit of the Supreme Court, which has that original jurisdiction. That's not what the Speaker did. And the matter, be that as it may, the matter was taken to the Supreme Court. And I'm saying that even if the matter had gone to the Supreme Court, the procedure that the Supreme Court used, for instance, to grant the interim relief that were being sought was problematic. And I think many lawyers have expressed this to you. I mean, a party goes to court and says that I'm asking for an application to stay execution of the Speaker's relief for a period of 10 days. The Supreme Court on its own decides to make it interlocutory, i.e. pending the final determination of the matter. I don't know where this happens, for instance. And so the Supreme Court sets a new judicial position or a position when it comes to such matters. So subsequently, when the party goes to court, his argument he can apply for an interim relief for 10 days, and then the court itself can so to say that I'm giving you more than 10 days. A party gets what he asked for in court. Okay, and the court has a duty to grant only what the party has asked for.
So the court cannot give
the court,
even when if the court feels that you deserve more. The court can't do that.
The court, in certain circumstances, the court may do that. But in this particular scenario, if you go for a relief for 10 days, right? The court should give you 10 days, unless, of course, when you went to the court, you moved your position and began to argue for more days. I'm not sure that's what happened. And those who follow up in court did not report that in court, the lawyers began to ask for more than 10 days. If they had gone to the court and actually asked or varied their position and asked for more than 10 days, then we can say the Supreme Court can even do that. But here is the case. That's not what happened in this circumstance. And I find it also worrying that the Supreme Court creates the constituencies into natural persons or even body corporates and ascribes democratic and constitutional rights to constituencies. I mean, how does that happen? The Supreme Court said it clear, but if the four seats were declared vacant, those constituencies will be private.
Albert, can you hear me?
Right?
Albert, can you hear me? Yes, the connection was breaking at a certain point. You said that you had issues with the Supreme Court ascribing human. If I think I missed a bit of it, but natural rights to the constituencies. Yes.
Yes, ascribing human rights and democratic rights to a constituency. The Supreme Court says that those four constituencies, will be deprived their democratic and constitutional rights of representation. I mean, are the constituencies individual? Are they body corporates, for instance? So sometimes I feel like the Supreme Court, when the Supreme Court decides, no matter how wrong it is, it may become the new position of the law. Okay? But I think that there are issues of fair hearing that also may have arisen in connection with that application. All right. Now, if the Supreme Court was minded, for instance, to take a decision or to give a ruling that would hold the hands of the Speaker in respect of these four MPs until the main interpretation suit is determined, then the Speaker ought to have been heard, for instance. So I think it would have been proper for the Supreme Court to have given the opportunity and brought that application which was sent ex parte to the attention of Parliament, or to the attention of the Speaker. So the Speaker can come and argue as to why the Supreme Court should not grant such a relief which was being prayed for. I mean, these are basic principles of natural justice. You don't decide a matter which affects the powers or rights of another person without hearing them. And these are so fundamental.
And interestingly, in the Supreme Court's ruling in relation to this case, it equally argues that the principle of fair hearing was not applied in the case of the four MPs.
Well, but you see, that's the point. That's why I made a point under Article 97, that the Speaker was just a mere procedural issue that happened. The Speaker was not declaring. I do not think the Speaker was just applying the law.
Okay.
All right? Because the conditions under 97, from the understanding of the Speaker, who is the master of the rules in that house, right? Realize that or observe that those conditions had occurred. And so he went ahead to make a statement or a ruling on that.
Okay, so if it was just an application of the law, one would say that why are we having a tussle over who is the minority and the majority? And because he didn't declare any seat vacant, he only applied the law. But at the moment there's a tussle between the NDC group and the NPP group, arguing that they are all the majority side.
Yeah, but there's a tussle because the conditions which, the Constitution provides for under Article 97, according to the Speaker, had occurred. I mean, if you enter Parliament as an independent, and then while you are still in Parliament, you file to contest on the ticket of another political party. Look, it's very important we realize that at the time when you decide, the intention has always been there. I mean, I do not think that there's any ambiguity about these provisions. For which reason we have to rush to the Supreme Court for interpretation. It is clear. Previous Speaker applied the same rules. Okay, so so the Speaker was just saying that, well, the conditions are clear. Those conditions have occurred. Ordinarily, the duty was on the member of Parliament to walk out, that having brought to his attention. But if the member doesn't walk out and the Speaker makes an affirmation or gives an affirmation of the position, right, in which case he was not placing interpretation, because when the rules are clear, you don't embark on the adventure of interpretation. 97 971G and H, many people have held a view, it's quite straightforward. And so if the language of the law is clear, my sister, why do you want to go and look for interpretation when there are no issues of interpretation? All right. So the speaker just applied the law. He didn't interpret the law, and so he has done his bit. And ordinarily, we shouldn't have been here. But some take the view that the speaker was wrong, and so they have gone to court.
The Supreme Court. Okay.
And I'm thinking that, and there's one more. Let me make this point. See, when we talked about and this issue about the standoff between the judiciary and the legislature, sometimes it can even be between the three arms of government. Now, to be very honest, when we adopted the hybrid system, we're combining some features of the presidential system of government and the parliamentary system. We were very much aware that Parliament under the parliamentary system, for instance, in the UK, has a lot of powers. In fact, Parliament is much more powerful than all the arms in the UK. But in our case, all the arms are equal in terms of power. So our constitution talks about supremacy of the constitution, not supremacy of any of the arms of government. So when we adopted the hybrid, we knew that we were giving Parliament as much power as we were giving the executive, as we were giving the judiciary. And for me, this is very, very important. So and I think that this is where the Supreme Court must begin to exercise some restraint. Now, I'm sure that you are aware that there's a concept in constitutional law referred to as constitutionalism, where limits are placed on government power in advance. Now, one of the key elements of constitutionalism that we don't talk about mostly is psychological constitutionalism, where those who exercise the power must know when to pull the brake, must know when to exercise their power.
Okay.
Because if you exercise the power in a way that upsets the balance in Parliament, then we are throwing the concept of separation of powers to the dogs. So you have to be careful when you exercise the power. And I think that such intrusions into the affairs of Parliament must be very rare. I think they're becoming one too many. And the intention of giving certain powers to Parliament is really being defeated.
It's being eroded.
And I dare say that if you really want to allocate power to people, right, or to groups, Parliament is the safest group to invest power in. Parliament is the safest because they're representatives of the people and not the judiciary, not the judiciary. And not the judiciary, because the judiciary are not elected officials. The Supreme Court may go to Parliament for vetting, members may go to Parliament for vetting and all that, but it doesn't fully make them the reps of the people, although they work in the name of the people. So Parliament is the safest place to put power because there are so many powers. They can call on the executive to appear before Parliament. The judiciary cannot do that. The judiciary can only come when somebody has invoked its jurisdiction. So it is somewhere, unless somebody goes to them. But Parliament can call on the executive to appear before it by its procedures. And so we should be careful when we deal with such matters because the separation of powers concept is not just any concept, but it has to be done in a way that does not put one power over the other. You can check, but when you are checking, be sure that you don't upset the balance of power based on which the balance of power on which separation of powers is based.
And now, Albert, you have pointed out all the flaws in the procedures adopted by the Supreme Court and even the decision to go to the Supreme Court in the first place. Yet again, you argue that despite this ruling being flawed in the eyes of many and per the procedure, the House or the Speaker should abide by it. One would argue, how is that fair? Even when on the face of it, on the facts of it, and looking at the procedures, the Supreme Court was procedurally wrong. We should still go ahead and abide by that ruling.
Well, I made a point that when the Supreme Court declares the state of the law or makes a statement of the law, that is the law, wrong as it may be. Did you understand what I'm saying?
Yes.
And so until that ruling, for instance, is set aside, I mean, it's my respectful opinion that we may have to respect the ruling of the court. The thing is that whether Parliament will act in accordance with that is also purely, I can say, at the discretion of how the Speaker interprets what he has before him. Right? So although I take the view that whatever went on the Supreme Court is troubling and is worrying, I cannot be heard saying that clearly that the Speaker should disobey the orders of the court. But I think that it is purely within the domain of Parliament to decide what to do with the ruling coming from the Supreme Court, and that's what I think about this matter. Yeah.
Okay, because we've heard some of the MPs, for instance, on the NDC side, saying that for them, they are only listening to the Speaker, and then the Supreme Court cannot come and enforce the ruling in the chamber.
Well, the thing is that the Supreme Court doesn't enforce rulings. Okay, it's the party in whose favor the ruling has been given
who is expected to enforce.
All right. So the Supreme Court will not go to the House to go and enforce. I mean, and nobody does that. For instance, if there were going to be any enforcement in this, then someone will have to go to the court again, and assuming that something happened today, or there was a clear indication that there was going to be a clear, the Parliament was not going to respect, for instance, or was not going to comply with the directives that had been given by the Supreme Court, then somebody may want to go to court and say that, well, there's contempt of court and things like that. But that also goes into other areas altogether, because there are provisions which says that when the Speaker is doing his work and all that, he will not be subject to any such criminal proceedings and things like that. So it's a bit complex. But I think that at this level, in order not to create a standoff and a threat to our current democracy, decisions have to be taken.
Okay.
I know a lot of talking. I am aware a lot of talking has been going on. I've seen videos in which the Speaker was heading to Jubilee House, amongst others. I don't know how true those videos are, but if it's the case that some talking is going on, I believe this matter can be resolved in a way that preserves the dignity of all the arms of Parliament and does not make one less important than the other. So that's how I see all this. It's our democracy will grow. I mean, so we occasionally come to this tipping point, and we have to work around it. So basically, that's what it is. Yeah.
All right, Albert. Thank you so much for speaking to us. It's been great engaging you.
All right. I appreciate it.
Have a wonderful day. Albert Quashigah is a constitutional law lecturer at the UPSA Law School. He also used to host analysis here on Star 103.5 FM in the lead up to the 2020 elections. And so it's always refreshing to engage Albert on legal issues. This is still the Morning Star here on Star 103.5 FM. Let me hear from you, your thoughts on how everything is unfolding. We'll be speaking to Ibrahim Alassan, our parliamentary affairs correspondent, shortly in relation to what is happening in the chamber. While I wait to connect with him, let me hear from you from all the perspectives we have heard this morning. Earlier we heard from the Earlier we heard from the NDC group, the chief whip, Kwame Governs Agboja, speaking about what had happened early on in the morning. We've also spoken to a constitutional lawyer in relation to how everything has unfolded. He points to the many flaws in the Supreme Court's ruling, but he says, despite the flaws in preservation of our democracy, he believes that it will be better if the Speaker or the House just abides by the ruling, and he hopes that progress will be made going forward. That from time to time we do reach a certain tipping point, but we always emerge victorious from some situations such as these. So the number to reach us on is 0535 183317. Let me go for a short break. When I return, I will definitely be hearing from you. It's a Morning Star here on Star 103.5 FM.